Welcome to the final session of the Greenlaw Global Institute Climate Justice International Moot Court competition between Catholic University of Eastern Africa and University of Zimbabwe. I'll be the court registrar. My name is Brian Awunda. I'll also be the timekeeper and the court assistant for this session. Before you is Catholic University of Eastern Africa representing the state of Azania, and University of Zimbabwe representing the entity of SECA. With that, I declare the session open and give it to the presiding judge, Judge Justice Ellen Omondi, to proceed from there. Welcome, Judge. Court is in session.
Thank you, and a very good afternoon. The registrar has already set out the rules of engagement, and we will not spend any more time with the other preliminaries. And all I'll do is therefore now to request the registrar to call out the first parties to address the court.
Thank you, Honorable Judge. With that, I call out Catholic University of Eastern Africa, representing SECA. You have 45 minutes. I will remind you intermittently of your time usage. Welcome.
President of this Honorable Court,
Apologies. University of Zimbabwe, we can't see you. Annie and Lauren, your cameras need to be on at all times. Right, proceed.
President of this Honorable Court, Lady Justice Ellen Omondi, Your Excellency Lady Justice Antoinette Ogange, Your Excellency Justice Matthew Emekule, Your Excellency Justice Eric Feuri, and Your Excellency Justice Bozi. Good evening. My name is Nick Kimathi, appearing alongside my very able co-counsel, Mr. Timothy Kamore, both representing the state of Azania. I take this opportunity first and foremost, Your Excellencies, to simply state how much honored we are to appear before this particular court. Your Excellencies, with the 45 minutes that have been graciously allocated to us, we'd like to utilize our time as follows. I will utilize the first 23 minutes to canvass on the issue of jurisdiction and admissibility, issue 1, 3, and 5. And my co-counsel, Timothy Kamore, who will equally introduce himself, will utilize the subsequent 22 minutes to canvass on issues 2, 4, 6, and consequently give out our prayers to this Honorable Court. May it please this court, I'd like to move to the substantive issues. Your Excellencies, every environmental crisis begins the same way, as a wound nobody chose to see. Millions of tons of textile waste don't appear in a single catastrophic moment. One would say they may even take 3 decades. They accumulate thread by thread in landfills, on the shorelines, and even in rivers that once would run clear enough to drink. Azania looked at that wound and chose that it would not look away. The choice found its name in the language of this court's own contemporaries. The International Court of Justice, in the very year Azania acted, held that a clean, healthy, and sustainable environment is not a peripheral concern. It is the precondition beneath the right to life, to health, and to water and shelter itself. Your Excellencies, the Dutch Supreme Court reached the same diagnosis in agenda. Azania simply did not wait for permission to treat a wound everyone else could see. The TWCCA is that particular treatment, where we have the extended producer responsibility, the digital traceability, which are not experiments, but proven instruments that have been trusted elsewhere, now put to work for the sake of Azania's own people and its land. Your Excellencies, nearly 2 decades ago in Oslo, a daughter of this very continent stood before the world and said that humanity must learn to heal the earth's wound, and in doing so, heal its own. This daughter goes by the name Wangari Maathai. Azania is not asking this court to invent that idea. Azania is simply asking this court permission to keep believing it. Excellencies, with that opening statement, I proceed to the issue of jurisdiction. It is Azania's position that this court is clothed with sufficient jurisdiction to pronounce itself and render an advisory opinion on the matter that has been presented to it by the United Nations General Assembly. This is pursuant to Article 96.1 of the Charter of the United Nations, as read together with Article 65.1 of the Statute of the International Court of Justice, Your Excellencies. In this particular regard, I make reference to the 1996 ICJ advisory opinion on the legality of the threat or use of nuclear weapons, together as read with the 2025 ICJ advisory opinion regarding the obligations of states with respect to climate change. With that, Your Excellencies, I proceed to the first issue. Your Excellencies, the first issue poses the following question to this Honorable Court: whether the ICJ advisory opinion affirms a positive obligation on states to regulate transboundary value chains, including the second-hand apparel trade that contributes to climate change and environmental degradation. It is Azania's position that the advisory opinion does actually affirm a positive obligation on states. And as we affirm these particular positions, Your Excellencies, I shall be making reference to the following authorities: the pulp mills on the River Uruguay case, the 2024 ITLOS advisory opinion, the Bosnia versus Serbia and Montenegro case, the Gabčíkovo-Nagimoros project case, which shall constitute my list of authorities for this particular issue. Your Excellencies, the affirmation of this particular obligation came through paragraphs 281 and 282 of the 2025 ICJ advisory opinion by the court, which shall form my first line of argument under the obligation of due diligence. The court proceeds to affirm and recalls that due diligence requires a state to use all the means at its disposal to avoid activities that take place either in its jurisdiction or under its territory from causing harm to the environments of other states. This particular pronouncement by the court was with particular reference to paragraph 101 of the pulp mills on the River Uruguay case. Your Excellencies, the court then proceeds in the same paragraph to explain what exactly is required by this particular obligation of due diligence. And this is where they make reference to paragraph 235 of the ITLOS advisory opinion in saying that states ought to put in place national systems, including legislations, such as in the present case where we have the TWCCA, and administrative procedures, as well as enforcement mechanisms that shall see to it that the activities are regulated and do not result in the environmental harm that we so much want to present, Your Excellencies. Your Excellencies, the affirmation of this obligation of due diligence did not come instantaneously, but rather, very far from it, it came from a very nuanced consideration by this Honorable Court through paragraphs 136 to 138, Your Excellencies. This particular Honorable Court notes that this obligation of due diligence has several elements, some of which were considered by the court in paragraph 137, such as whether a significant risk has been indisputably established and the overall character of the risk itself, the harm that is being in question, whether it has that general universal character, Your Excellencies. Following these considerations by the Honorable Court, it was able to reach a very conclusive decision in paragraph 138 that the standard required by this particular obligation is that of due diligence. And as they were arriving at this decision, it was at this point they made reference to the Bosnia versus Serbia and Montenegro case, where they were able to view the facts and circumstances in concreto. In concreto to mean they were able to analyze the factual circumstances from a realistic standpoint, Your Excellencies. Your Excellencies, I move on to my second limb of argument, under which I shall discuss the duty to prevent significant harm on the part of the environment. Under this particular duty to prevent harm to the environment, Your Excellencies, the court in paragraph 272 reaffirmed and echoed the Trail Smelter Arbitration Award, which is significant because it was the first time the duty to prevent was being identified as a principle of international environmental law. Your Excellencies, under this particular duty, no state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another state. Allow me, Your Excellencies, to refer to the opinion of Judge Charlesworth, where she was able to distinguish between the precautionary approach and the preventive approach, which governs the duty to prevent. She was able to distinguish the two while making reference to the International Law Association's Declaration of Legal Principles relating to climate change, particularly Article 7A and 7B. She was able to differentiate the two, noting that the difference comes in with the scientific certainty and knowledge that comes with the duty to prevent, which is under now the preventive approach, Your Excellencies. Looking at the present case that is before this Honorable Court, Your Excellencies, the state of Azania has an adequate scientific knowledge and certainty following the government-commissioned environmental audits and the scientific studies that have been presented to Parliament when this particular TWCCA was being enacted. What these scientific studies reveal is that as one of the factors that was considered by the court is we have a significant risk that has been indisputably established in the form of the prevailing toxic emissions. We have the black carbons as well, and the microplastic pollution, which is significantly and negatively affecting the marine environment of Azania. Your Excellencies, at this point, I refer to paragraph 283 of the 2025 ICJ advisory opinion that reminds us where there is generally scientifically recognized evidence that significant harm should occur, the standard of due diligence remains more demanding for all states. And over and above, Your Excellencies, we are informed from paragraph 294 that that state which chooses to disregard this scientific evidence will be found to be in breach of its obligation of due diligence. And it is for this reason that we ask that this Honorable Court finds in our favor that the state of Azania was in compliance with the obligation of due diligence, and following its enactment of the TWCCA, it was only using all the means at its disposal to ensure, Your Excellencies, that we are able to discharge the duty effectively and come up with a legislation and other administrative procedures and enforcement mechanisms. Your Excellencies, with that, I'd like to proceed to the second issue. The third issue, rather, which poses... Yes, Your Excellency. Okay. On to the third issue, Your Excellencies, which poses the following question to this Honorable Court: whether measures adopted pursuant to the ICJ advisory opinion may justify limitations on international trade under environmental and human rights exceptions. The position of Azania regarding this particular issue, Your Excellencies, is to the affirmative, that the measures that have been adopted pursuant to the ICJ advisory opinion, specifically in this case under the TWCCA, it is our position that these measures are justified in their limitations to international trade. As we continue affirming our position as the state of Azania, we make reference to the following authorities. We shall refer to the General Agreement on Tariffs and Trade, that is GATT. We shall also refer to the Agreement on Technical Barriers to Trade, that is the TBT, Your Excellencies. We shall also refer to the Brazil retraded tires case, and subsequently make reference to the Gabchikovo-Nagimoros project case. Your Excellencies, the general purpose that is to be served by GATT, in essence, is to promote international trade. However, a good look at Article 20 provides for the general exceptions, which are the measures which, if they are justified for being implemented in a way that is not amounting to arbitrary or unjustifiable discrimination, nor a distinguished restriction on international trade, these measures are to be held as justifiable in the limitation on international trade. More specifically, I refer to Article 20B and G, whereby Article 20B speaks of those measures relating to the animal, human, and plant life or health, and 20G, which speaks of the exhaustible natural resources that are found in the environment. Your Excellencies, what is coming out clearly is that these are measures that the general agreements and general agreements on tariffs and trade had envisioned would be necessary in some instances to be able to restrict international trade. I also refer to Article 2.2 of the Agreement on the Technical Barriers to Trade, TBT, where the aforementioned measures, Your Excellencies, are noted to be legitimate objectives, which, if pursued, would be justifiable for the sake of not only the economic aspect, but also for the sake of the sustainable development as well. A perfect example of where these particular exceptions have been applied would be the Brazil-Eritrea tires case, where the state of Brazil was able to acquire provisional justification from the World Trade Organization appellate body. It was able to acquire provisional justification for invoking Article 20, under which the legitimate objectives were used. However, the distinguishing factor comes in when we are looking at the application of the requirements under the chapeau of Article 20 itself. And in this particular case, under the case that is currently before this Honorable Court, Your Excellencies, it is to be said these measures which are being implemented under the TWCCA, adopted pursuant to the ICJ advisory opinion, are not being applied in a manner that constitutes to arbitrary or unjustifiable discrimination, nor are they a disguised restriction on international trade. And it is for these particular reasons, Your Excellencies, we ask this court that it extends significant weight to these two legal instruments. Your Excellencies, I proceed to refer to the Gabchikovo-Nagimoros case, where Judge Wiramantri famously said that the need to reconcile economic development and environmental protection is aptly expressed in the concept of sustainable development. Sustainable development, Your Excellencies, was clearly defined in the 1987 report by the World Commission on Environment and Development titled Our Common Future. The report proceeds to define sustainable development as that approach which sees the achievement of the objectives of the present generation without having to jeopardize or compromise the chances that future generations have in also achieving their own objectives and interests, Your Excellencies. For this particular reason, Your Excellencies, I would be making a reference to a further description of the concept of sustainable development by the United Nations itself, where the UN likens the sustainable development to a juggling act where it speaks of three balls which, if any of them falls, it can no longer be termed to be sustainable. The three balls, Your Excellencies, in this particular instance represent three pillars. The first one being economic development, the second one being environmental protection, and last but in no way the least, we have the social inclusion. In the present case that is before this Honorable Court, the situation regarding Azania's second-hand apparel trade, we have, Your Excellency, 2.5 million people who are employed in this particular industry, 2.5 million people who handle a 35 to 45% unsellable portion of the garments that come into the country. And you're being informed that one of the reasons why this unsellable portion cannot enter into the market is because it is contamination which could range well between bacterial contamination or even the chemical contamination from the residual chemicals and the residual dyes that are used in the textile industries. Biological contamination itself encompasses aspects of mold infestation, bacterial growth, and even the fungal infections, Your Excellencies. And this directly speaks to the health of these workers. The health in question falls under this particular pillar of social inclusions, which would ordinarily cover aspects of the fair working conditions and the healthcare that is being accorded to the employees. Seeing that this particular pillar is falling, I'd like to proceed now to the pillar of the environmental protection, Excellencies. We have the means of disposal of this unsellable portion where it is being disposed in open land, in informal landfills, open systems, open river systems, and it is being banned without even regulation, leading to the release of toxic emissions and the black carbons, Your Excellencies, which has significantly and negatively affecting effects on the environment of Azania, seeing also that the environmental protection pillar cannot stand anymore. It is for this reason that we assert as the state of Azania that the trade, the second-hand apparel trade as is, cannot be termed to be sustainable. And we therefore ask that the measures which have been adopted pursuant to the ICJ advisory opinion under the TWCCA be found to be justifiable so that they can be able to regulate the trade and have it come to a sustainable standard, Your Excellencies. Your Excellencies, I proceed to the fifth issue, which asks this honorable court whether the continued exposure of children and coastal communities to apparel-related pollution violates international human rights obligations, including the intergenerational equity as articulated by the International Court of Justice. It is our position that the continued exposure to this particular pollution, Excellencies, is actually a violation of the international human rights. And so the question that would come to the mind of this court, Excellency, is what particular violations are being, what particular rights are being violated. In answering this particular question, Your Excellencies, I shall make reference to the following authorities. I shall refer to the African Charter on Human and People's Rights, the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, that is the Maputo Protocol. I shall also refer to the African Charter on the Rights and Welfare of the Child. I shall also refer to the articles on the responsibility of states for international wrongful acts, together with the Teitiota versus the New Zealand case, as read together with also the General Comment number 36 of 2019. And in conclusion, I shall be referring to the SERAC and CESR versus Nigeria case, Your Excellencies. Your Excellencies, the following provisions are clearly being violated in the state of Azania following the effects of the second-hand apparel trade. We have Article 16 and 24 of the African Charter on Human and People's Rights, which can be very clearly seen in the SERAC and CESR versus Nigeria case, where Nigeria was found to be in violation of the two provisions, where we have Article 16 providing for the best attainable state of physical and mental health, and Article 24 guaranteeing that every individual is to enjoy a satisfactory environment which is favorable for their development. Your Excellencies, we move on to the Maputo Protocol, that is the protocol to the African Charter on Human and People's Rights on the rights of women in Africa, where Article 18 is equally being violated as women are being guaranteed the right to live in a healthy and sustainable environment, which is not the case. Similarly, we still have the African Charter on the Rights and Welfare of a Child, Article 14, where children are being guaranteed the right to the best attainable state of mental, physical, and spiritual health. Looking at the present case in Azania, none of these rights are being implemented, Your Excellencies. We have the environment which is being polluted left, right, and center. We have the microplastic pollution, we have the toxic emission and the black carbon emission as well, Your Excellencies. We also have the form of disposal of the 35 to 45 unsellable portions, which leads to flooding, exacerbated flooding, and the waterborne diseases that still bear significant negative effects on the health of the people of Azania, Your Excellencies. So this informs our position of the violation on the international human rights, Excellencies. However, in as much as it is our position that the aforementioned provisions are being violated, we still proceed to assert that the same cannot be attributed to the state for the following reason. Your Excellencies, Article 2 on the articles of the responsibility of states for internationally wrongful acts requires that for a state to be held responsible for an internationally wrongful act, we ought to have, one, an act or omission that violates an international obligation, and 2, that particular breach of international obligation ought to be attributable to the state. We proceed to assert that this particular condition has not been met for purposes of Articles 4 to 11 of the same provision that clearly give a very comprehensive list of conditions that will now render the state to be liable. But in the present case, looking at the present case, Your Excellencies, none of that, none of the conditions between Articles 4 to 11 have been met. Furthermore, to build on that, I'll be referring to now the ILC principles of 2006 on the allocation of loss in the case of transboundary harm, where we have the harm being caused by hazardous activities. Principle 4 of this particular instrument allows states to impose liability on private actors who are behind the harm. And the liability that is being imposed here, it does not require the proof of fault, further speaking to the strict liability, Your Excellencies. Nonetheless, the state of Azania is cognizant of the role that it requires to play to ensure that this environment serves not only the needs of the present generation, but future generations as well. In doing so, Your Excellency, I proceed to refer to paragraph 29 of the 1996 advisory opinion, the legality of the threat or use of nuclear weapons, where the court pronounced itself as follows: that the environment is not an abstraction. The environment is, however, the living space and the very health of the human beings, including generations unborn. And at this point, Your Excellencies, I would like to refer to the Teitiota versus New Zealand case as read together with general comment number 36 on Article 6, both from 2019 by the United Nations Human Rights Committee, where it was held that climate change, unsustainable development, and the environmental degradation, they all constitute some of the most serious and pressing threats to the ability of both the present and future generations to enjoy their rights, Your Excellencies. With these particular authorities in mind, Your Excellencies, it is again our prayer to this Honorable Court that it may see this particular case in our lens and approach, that the measures that have been adopted pursuant to the TWCCA are a necessary need, are a necessity to ensure that this particular trade, the second-hand apparel trade, is regulated to a sustainable standard that would see the needs of the future generations met as well. And as I cede floor to my very able co-counsel, I finish in the words of Mr. Eugene, who just spoke as we were opening, that we do not inherit the earth. Rather, we borrow it from our children, Your Excellencies. Thank you.
20 minutes, Team Queer, 20 minutes.
Much obliged. May it please this Honorable Court, good evening once again. Your Excellencies, allow me to ride on the protocol observed by my co-counsel, Mr. Nicky Matthew. As introduced earlier, my name is Timothy Kamore, and I must reiterate that it is indeed an honor to appear before this Honorable Court, an intellectual bench to submit on the matter beforehand. A matter Judge Tladi noted in his declaration on the obligation of state advisory opinion that this issue on climate change is one of the most consequential issues in the history of the court. I will therefore exhaust the remaining 20 minutes to unpack our arguments on issue 2, 4, and 6 respectively, and conclude by surrendering our prayers to this court. Your Excellency, I would also like to seek your humble request to ignore any break in my voice. Unfortunately, a common cold decided to attack me conveniently early this morning, but regardless, we thank God for our appearance here. If it may please this Honorable Court, I would like to proceed. On the second issue in regards to this matter before this Honorable Court, on whether Azania's failure prior to the Textile Waste Control Act to regulate second-hand apparel imports constituted a breach of the due diligence obligation under international law, the state of Azania veritably asserts before this Honorable Court that Azania's failure to regulate the second-hand apparel trade prior to this Textile Waste Control Act was not a breach of the due diligence obligation because the due diligence obligation had not evolved to encompass the specificities of textile waste management. And as I proceed with our arguments in regards to this matter, Your Excellencies, I will make references to the following inspirations of international instruments. I will use the United Nations Framework Convention on Climate Change. I will also use the Kyoto Protocol, the Paris Agreement, the Trail Smelter Arbitration 1941, the Alabama Claims Arbitration of 1872, the Rio Declaration, the Stockholm Declaration, the ILC draft articles on prevention of transboundary harm from hazardous activities, and other soft law principles, Your Excellencies. And our arguments on this matter will be based on two limbs. Number one, the risk of transboundary harm, significant transboundary harm, and number two, common but differentiated responsibilities. Because, Your Excellencies, you will find that these two limbs play a crucial role in determining the due diligence obligation of states in respect to climate change. On to the first limb, Your Excellencies, while it is no understatement to say that climate change is the greatest threat facing humanity and all of life on Earth today, I beseech this honorable court to agree that the causes and impacts of climate change were slow to occur. Your Excellencies, international environmental law has arguably gone through 4 key phases in development. And one of the major developments has been highlighted by my co-counsel, Mr. Nicky Mathy, being the no harm rule that was established by the Trail Smelter Arbitration in 1941. This no harm rule establishes the due diligence obligation of taking preventive and minimization measures, Your Excellency. However, as reaffirmed in the pulp mills on the River Uruguay case, this duty to prevent significant transboundary harm only applies to activities which involve a risk of causing significant transboundary harm. And what activities are these, Your Excellencies? The ILC draft articles on prevention of transboundary harm classified such as activities as hazardous activities and were unable to develop a generic or complete list to highlight these activities because of the evolving technology that we are now facing, and therefore found that it would be incomplete and quickly outdated. Therefore, Your Excellencies, the mere fact that harm eventually results from an activity does not mean that the activity involved a risk, if no properly informed observer was or could have been aware of that risk at that time. On the other hand, an activity may involve a risk of causing significant transboundary harm, even though those responsible for carrying out the activity underestimated the risk or were even unaware of it. Thus, it is possible for that activity, which in its inception to not involve any risk, but might come to do so as a result of some development in scientific knowledge, which is the present case of the Republic of Azania, Your Excellency. And after putting emphasis into the determination of what is a risk, Your Excellencies, I would also want to expound on what is significant as defined in the Code of Conduct on Accidental Pollution of Transboundary Inland Waters, whereby they found that the term significant is not without ambiguity, and that this term significant encompasses something that is more than detectable, harm that leads to a detrimental effect on health. And as long as it has not reached this level, it is considered tolerable. For example, Your Excellencies, a particular deprivation at a particular time might not be considered significant because at that specific scientific time, the scientific knowledge or human appreciation for a particular resource had not reached a point at which much value was ascribed to that particular resource. But some later time, that view may change, and the same harm might then be found to be significant, Your Excellencies. Now, in the present case, Your Excellencies, I invite you to see the point of view of the Republic of Azania, whereby historically the transboundary impact of second-hand clothing was primarily viewed through an economic lens rather than an environmental one. This regulatory uncertainty meant that states lacked a clear benchmark for managing the environmental impacts of such trade with respect to global emission reduction pathways. And Your Excellencies, we are aware that action with regards to phenomenon of global warming has also been a lot slower, the first serious effort to tackle it actually being the Vienna Convention for the Protection of the Ozone Layer. And therefore, Azania, being a state that had no information on the development of climate change jurisprudence, and also the fact that scientific evidence had not shown at that time for the effects of second-hand informal banning to be significant, it acted based on its reasonable directed efforts to greenhouse gas emissions and not informal banning of apparel waste. And in relation to the second limb of my arguments under the due diligence obligation, Your Excellencies, it was defined in the Alabama Claims Arbitration Case, Your Excellencies, that the due diligence obligation proportioned is the obligation proportioned to the magnitude of the subject and to the dignity and strength of the power which is to exercise it. And as was put across by my co-counsel, it is an obligation that calls for an assessment in concreto of what is reasonable under the specific circumstances. This obligation is as mentioned in the Principle 7 of the Rio Declaration, an obligation that should be matched in tandem with the common but differentiated responsibilities. And the common but differentiated responsibilities was also highlighted in paragraph 291 of the ICJ advisory opinion, whereby the degree expected of a state with a well-developed economy and human and material resources will be different from states which are not so well placed, Your Excellency. Therefore, Your Excellency, the informal economic reality of Azania is that its apparel sector sustains approximately 2.5 million workers, and this sector operates as a necessity-driven circular economy. It would therefore not be reasonable for Azania to rush and regulate and potentially dispose 2.5 million people without an ecosystem partner and a human rights-based strategy that we now have. And we therefore plead with this honorable court to consider that before the 2025 ICJ advisory opinion, second-hand apparel was largely treated as a trade commodity rather than a climate-forcing agent. If it may please this honorable court, I would like to rest that issue and proceed to the fourth issue in this matter. And on the fourth issue...
10 minutes, Team Quer.
Thank you.
10 minutes,
The
Team
fourth
Quer.
issue poses the following question to this honorable court on whether digital traceability and EPR requirements constitute lawful regulatory measures, Your Excellencies. And we submit in this matter, guided by international trade law and environmental law, that the state of Azania's implementation of digital traceability and extended producer responsibility requirements is a standard regulatory measure aimed at environmental protection. And Your Excellency, in this issue, it provokes one fundamental question that I would like the court to bear in mind. Why is it that despite the huge volume of international environmental law, the state of the global environment has continued to worsen? Part of this explanation lies in what one scholar noted as the traditional approach of international environmental law and trade law being treated separately. However, Your Excellency, in this time and contemporary situation, Your Excellency, international environmental law and trade law should be married together and involve performance standards that concern the making of the entire production system to be environmentally sound. And in this case, these performance standards are the digital traceability and extended producer responsibility requirements. Your Excellency, it is evident that the digital traceability and extended producer responsibility requirements have also gained recognition in the East African community, more so in the Kenya Petition 32 and 35 of 2017. The Environmental and Land Court at Nairobi ultimately held that although the plastic bag ban did actually limit the petitioner's rights, this limitation was reasonable and justifiable because the plastic ban is for the common good of the general public and as such lawful. Your Excellency, our wish is actually not to ban second-hand apparel trade. However, our wish is to ensure that this second-hand apparel trade is environmentally sound. At the same time, it satisfies the needs of the informal workers, and therefore it justifies the involvement of digital traceability requirements, which are there to protect the health of the women and the children, Your Excellencies, and also maintain the polluter pays principle, which was first introduced by the OECD Council, Your Excellencies. It has also been mentioned that Article 20 and the chapeau of the General Agreement on Tariffs and Trade justifies the involvement of such measures and also the technical barriers to trade agreement. Your Excellency, on to the sixth issue in regards to this matter on whether social enterprises operating within circular economy models may function as legitimate governance actors in fulfilling state climate obligations, we submit that certified circular social enterprises operating within circular economy model functions as legitimate governance actors in fulfilling state positive obligation. And I will make reference to the Aarhus Convention and Agenda 21 the Advisory Opinion 2025, and several writings by distinguished scholars, whereby, Your Excellency, we find that the effectiveness of international environmental law will also be partly dependent on us breaking out of the pernicious influence of the pervasive concept of state sovereignty, whereby we have to involve a range of non-state actors and escape that kaleidoscope of where it is only the state that should be responsible for governance, Your Excellencies. And what governance are we looking at, Your Excellency? We're looking at a governance, in particular environmental governance, that is diverse and accommodates all communities at every level. The Aarhus Convention presently applies this governance. And it was noted by Kofi Annan that although regional in scope, this convention is an impressive elaboration of Principle 10 of the RIA Declaration that stresses the need for citizens' participation in environmental issues and for access to information on the environment and the environment held by public authorities, Your Excellencies. Similarly, the Paris Agreement emphasizes on a capacity building approach on recognizing circular social enterprises, Your Excellency, through a just transition and a collaborative governance model such as polycentric governance systems, Your Excellency. Therefore, Your Excellency, using a just transition where we're ensuring that no one is left behind, Your Excellency, and a polycentric governance model whereby we accommodate the diverse communities, we are incorporating a model that leaves no informal worker behind. The Republic of Azania.
5 minutes.
Thank you, much obliged. The Republic of Azania, facing a unique governance challenge, requires a model that incorporates the 2.5 million workers, because traditional state-centric regulation is insufficient to address these challenges. It is ill-suited to address complex environmental problems like textile waste, and therefore, this is what precisely Azania does not require. It requires a governance system that can adapt to local conditions, experiment with different approaches, and learn from success and failures, Your Excellencies. And by recognizing circular enterprises as social actors, we extend administrative control to the grassroots levels and approach the informal workers of this sector in an ethical manner, Your Excellencies. And Your Excellencies, as I rest our submission on this matter, you will agree with me that states thrive more on established trust systems that are inclusive of all sectors, and there is a profound truth in the saying that trust develops slowly. It is like accumulating coins in a jar. Social enterprises are the vessels in which this trust is stored, Your Excellencies. They possess the granularity and legitimacy to manage the transition to a circular economy while ensuring inclusive and decent work. And given the compelling evidence, Your Excellencies, we humbly request this esteemed body to clarify that states enjoy sovereign regulatory discretion to design and implement environmental and climate legislation, including the Textile Waste Control Act. Secondly, that the ICJ advisory opinion on climate change provides states with flexibility in determining appropriate regulatory measures suited to national circumstances. Thirdly, that the Textile Waste Control Act constitutes a lawful, necessary, and proportionate measure to climate change, environmental degradation, and transboundary textile waste. And lastly, Your Excellency, that the effective climate action requires coordinated international cooperation, but the absence of comprehensive global regulation does not preclude states from adopting robust domestic measures to meet the international obligations. And with that, Your Excellencies, we yield the floor back to the bench. Thank you.
Thank you very much, Council. I will ask the judges if anyone has an issue they would want to address. Judge Professor Bozi, any issue you'd want Council for Azania to address?
No, Judge, no.
Thank you. Thank you. Senior Counsel Judge Eric Theory.
Presiding Judge, I think I just have a minor question to the submissions that have been made by the advocates for Azania, and that is with regards to the question of the inconvenience, is there any measure that the state has put in place to ensure that the vulnerable groups, these are the women and children that are largely supported through the sale of these apparels, are not affected, or rather unduly affected in terms of their economic social rights by the requirements for digital traceability, and whether the state found it necessary to impose any quotas for the various social actors as they comply with this requirement.
Thank you, Your Excellency Justice Eric Theory, for that question. And your question bears an inspiration in mind of what Judge Charlesworth was mentioning as incorporating vulnerable groups that are affected by climate change when transitioning to a circular economy, Your Excellency. And when mentioning the incorporation of vulnerable groups, Your Excellency, the state of Tanzania has incorporated the digital tracking and extended producer responsibility requirements at the point of importation, Your Excellency. This point of importation ensures that the burden of paying for the tracking does not fall unnecessarily on the informal workers, such as the women who work at the low level, Your Excellencies. And therefore, while implementing it at the point of importation and rather than at the point of consignment, where we have the go downs and the rest, Your Excellency, we're ensuring that this just transition leaves no one behind, specifically the informal workers, as mentioned, Your Excellency, and we are incorporating a governance structure that is polycentric. Much obliged.
Thank you, Judge Eric Theory. Are you done with the questions?
Yeah, thank you, Presiding Judge. I'm done.
Thank you so much. And Honorable Judge Ogange, Antoinette.
Thank you, Presiding Judge. Just one question for Council for the state of Tanzania. If the state knew that 35 to 45% of the imports were waste, how can you maintain that it lacked sufficient knowledge to trigger the necessary regulatory measures? Hope I'm audible, Council for Tanzania.
Much obliged, Your Excellency. You are audible. Allow me, before proceeding to a question, to ask the permission of the court to ignore any background noise. There is a heavy downpour and we have just lost power at my current location, but I am still able to hear you and able to respond to your question. Excellency, your question seeks to get a response on any other measures that could have been put in place in view of the information that the state of Tanzania had regarding the presence of 35 to 45% of unsellable garments. Your Excellency, the state of Tanzania, in view of the 35 to 45% unsellable garments, not only the unsellable portion, but the negative effects that it was visiting upon both the people of the land and the environment, has now proceeded to implement the TWCCA, under which certain measures such as the digital traceability and the extended producer responsibility have been put in place to ensure that we are able to tackle the effects, the negative effects that are being brought by this unsellable portion. In a bid to also answer your question, Excellency, we are doing so in a manner, as clarified by my co-counsel, in a manner that seeks to ensure no one is being left behind.
Thank you for your response. Thank you, Presiding Judge.
Sorry, I realized I was muted. Thank you, Judge. Honorable Retired Justice Mukule.
Judge Mukule has indicated there's a heavy lost his internet, so he's trying to get back and proceed.
Oh, okay, all right. Thank you very much. All right, then I will just seek a clarification, and either Mr. Kimathi or Council Kamore can respond to this. Just help me understand, look at your paragraph 6.8 of your submissions and 6.10 of the submissions. They are at page 25, I think. If you could just elaborate so that it's clear what you're communicating.
Thank you, Presiding Judge, Lady Justice Helen Omondi. In reference to paragraph 6.8, I believe it is in regards to the monocentric governance systems which are ill-suited to address complex environmental problems like textile waste, Your Excellency. The monocentric governance system, Your Excellency, as was emphasized by Elinor Ostrom, who is a scholar who gave her opinion on how polycentric governance systems are best equipped to deal with climate change adaptation of governance. We put across and we invite this court to bear in mind that the structure of dealing with environmental governance in climate change requires that we adopt a system that is of different scales, rather than a unit that only addresses local actions at the centralized level of the government, Your Excellency. And therefore, this polycentric governance, when implemented, leads to a more varied entrepreneurship, since we involve more second-hand apparel traders in the skills that are enhanced by the states, since there will be programs, environmental programs, that will be used in training these workers and making them aware through civic participation and public awareness on what are the changes being enhanced in the second-hand apparel trade. And this implementation of such a structure will enable them to adapt to local conditions and experiment with the different approaches, therefore leaving none of them behind. Have I answered your question sufficiently, Your Excellency?
Thank you. Yes, you have. Thank you very much, Council. I think Judge Mukule has not been able to join, and so we'll allow.
He's back,
okay.
Presiding Judge.
All right.
Judge Mukule is there. Yes.
Okay, I don't seem to see
back.
Oh, welcome back, Judge. Do you have anything for the Council for Azania, either Mr. Kimathi or Mr. Kamore?
I don't think you can answer my question, Presiding Judge. I need clarification on the issues of traceability with regard to the 35.5% contaminated textiles that are still being imported to the country with that knowledge. What is it that they can do with the TWCCA to reduce and eventually, maybe not eliminate, but substantially reduce the quantity of textiles that are contaminated? I haven't had argument about that or an opinion. Either of them can answer me. Council.
Thank you, Your Excellency, Justice Emukule. I would like to seek a clarification if you're asking what would the state do to reduce the impacts of the Textile Waste and Control Act, or to reduce the contamination of the textile textile clothing that comes as imports to the states?
Precisely, the latter.
The latter. Thank you, Your Excellency. Now, Your Excellency, to reduce the contamination of the textile import that is coming into the states, and as made in reference by one of the French ministers made a reference that Africa has become a dumping site of I think it's called fast fashion industry. My apologies, Your Excellency. Fast fashion industry. Now, to cap this impact, Your Excellency, the implementation of the digital traceability requirements and the extended producer responsibility requirements are being imposed at the point of importation, Your Excellency. Being imposed at the point of importation means that such clothing will have unique product passport identifiers, and that is what we call, Your Excellency, digital product passports. Because, Your Excellency, this clothing will therefore leave the global north and the European Union bearing these digital product passports and enter and continue down the chain of the transboundary value chain containing the product passports. Your Excellency, I would like the court to also bear in mind that by mid-2027, as reported by global regulations such as the EU Eco-Design for Sustainable Products Regulation, the DPPs, the digital product passports, are expected to be a mandatory requirement for apparel and textile wastes in the global north, Your Excellency. And therefore, that means through the Brussels effect, even without the local laws that Azania is requesting these courts to deem as justifiable, the state will directly be impacted by this regulation of the European Union. Why? Because of two reasons, Your Excellency. Number one, the exporter compliance, whereby major textile exporters in the United Kingdom and the European Union are increasingly required by their governments to ensure only high-quality reusable items are sent to Africa. And therefore, this means that grading happens at the source, and regardless of whether the reporting country has requested it, it will follow that apparel to the requesting country. And number two, because of the traceability of data, Your Excellency. Because as garments are sold in the European Union, begin carrying digital product passports starting in 2027, these digital tags will remain on the clothes when they eventually enter the second-hand market, and importers will naturally adopt this tool as it becomes a standard feature of the product. I hope I have answered your question sufficiently.
Supplementary question, Council. You're referring to legislation by the EU. What about Azania itself? Because elsewhere, you have restrictions on the type and of imports by way of inspection. That's a proactive measure by Azania. Why is Azania depending on the exporter's certification merely and not positive action on the part of Azania?
Much obliged. Thank you, Justice Emukule, for that question. A very important question. Now, the state of Azania is not relying on the exporters. However, we are using those regulations as a reference because Azania is a major importer of apparels from those global north states, Your Excellency. And however, as much as several states are using other measures to ban textile waste, textile second-hand clothing, for example, whereby in Uganda, President Yoweri Museveni announced a ban on the import, stating that these clothes are for dead people. Your Excellency, Azania is not doing that. Your Excellency, the state is trying to implement this EPR so as to achieve a transition that is justifiable and is a just transition that will not entirely ban the trade, but will, however, ensure that the industrial process of the textile waste trade, the textile second-hand clothing trade, is environmentally sound. Thank you, Justice Emukule.
Thank you, Council.
Much obliged.
Thank you. So if we are done with the questions from the bench, then I will invite the registrar to invite Council for SECA to make their submissions. Thank you.
Thank you, Presiding Judge. Thank you, Team Quer, for the submissions, and thank you to the bench for the clarifications. We now go to Team University of Zimbabwe representing SECA. You have 45 minutes. You can have the floor. Team UZ, are you there?
My apologies, sir. I had muted my mic. Presiding Judge, members of the bench, I am Lauren Mukanana, lead counsel for SECA, and I am accompanied by my co-counsel, Ms. Kudakwashe Masango. We are not here before this honorable court to merely argue legal abstractions, but we are here to vindicate the rights of 2.5 million Azanians that have been systematically targeted by their own government, Your Excellencies. We appear before you to discuss how the state of Azania is using environmental futurism to infringe on the rights of women, the rights of children, and the rights of the most vulnerable people within their citizenry. The legal theory that we rely on, Your Excellencies, is mainly three legal doctrines. Firstly, the doctrine of proportionality, Your Excellencies, that requires that state measures must be legitimate and commensurable to their objectives. Secondly, the doctrine of necessity, that obliges states to adopt the least restrictive measure available. And lastly, the doctrine of indivisibility, that states that environmental protection and human rights are inseparable and are interlinked. As Professor Lewis Kotz of the London School of Business highlights in his literature, The Architecture of Eco-Constitutionalism, protecting the environment at the cost of mass human destitution should be considered untenable. Humanity, Your Excellency, is the central organic component of the environment, and the two cannot coexist without each other. The central issue before this honorable court is that Azania has built a regulatory roof of stringent environmental policies that affect 5% of its population through the imposition of high technological processes, I beg your pardon, and excluding non-certified circular actors, Your Excellencies. They are doing what Dr. Richard Heeks, a professor at the University of Manchester in digital development, calls a mechanized purge on low-income micro-enterprises. The locus classicus that we would like to rely on in this particular moment is Argentina versus Uruguay, which was heard by this very court in 2010, specifically at page 14, wherein this very court found that state obligations must be assessed against their technical economic capacities, and therefore the arguments raised by our learned friends, Your Excellencies, cannot stand as the detrimental full-scale adoption of the advisory opinions paragraphs, Your Excellencies, has been misinterpreted and misapplied. The remedy we thus seek before this honorable court is that you humbly find that yes, there are climate obligations that are highlighted by the advisory opinion. However, these must be harmonized with socio-economic rights. Secondly, that informal circular actors should be seen as indispensable to the fight against climate change, not be considered the conduits of it. And lastly, Your Excellencies, that the TWCCA Act in its current state cannot be considered to be law internationally or domestically, and therefore should be subject to revision. If Your Excellencies are so pleased, I will now move on to my substantive arguments. Beginning with the issue of jurisdiction, it is prevalent that this very court is seized with jurisdiction pursuant to Article 65, Sub-Article 1 of the ICJ statute that allows the United Nations General Assembly direct access to this court. This read together with the UN Charter Article 96 that establishes that the United Nations General Assembly may seek an advisory opinion on any legal question it feels is prevalent and important for this court to answer, and therefore the relationship between the two entities is established. We would like to cite the case of the Palestinian war crisis of 2004, which was heard before this very court, and where you established again the true relationship between the ICJ and the United Nations General Assembly. Moving on to our main substantive arguments, particularly Merit 1. The question that is before this honorable court is whether or not the advisory opinion affirms a positive obligation to mitigate against transboundary harm. We are not here to argue against this, Your Excellencies, as we do believe that the advisory opinion is very clear. However, the manner in which the state of Azania has applied these provisions has been incorrect, and we are here to set the record straight. Firstly, Your Excellencies, the facts at page 2, section A, does highlight that the TWCCA Act restricts the second-hand clothing sector for 2.5 million Azanians as a response to the advisory opinion. However, we would like to highlight the paragraphs 237 to 249 that highlight that the Paris Agreement is the primary legislation that should be read together with the advisory opinion. And interestingly enough, Your Excellencies, the Paris Agreement preamble in its beginning sentence states that all states in their mitigation against climate change must respect all human rights, not just socio-economic rights, Your Excellencies, not just customary rights, all human rights. This is further supported by the Vienna Declaration, Part 1, Sub-Article 5, that again further states that there is no human right that precedes another, and that states should not pick and choose which rights to apply and which rights to take away in its implementations. The advisory opinion, I beg your pardon, again at paragraph 142, states that all states must be in strict conformity with existing rights, Your Excellencies. And again at paragraph 143, there is an anti-poverty mandate that is explicitly stated, which states that in states' pursuit in protecting the environment, there must be no exasperation of any form of discrimination. The TWCCA Act, Your Excellencies, in its current form, does everything the advisory opinion is against. We would like to cite the case of the Government of South Africa and others versus Group Boom, 2001, South African Law Reports 46, which is a constitutional case, and we are bringing before this court for persuasive value pursuant to Article 38 of the ICJ statute that allows us to do this. Justice Zach Jacob stated that socio-economic rights are justiciable and that state measures must be reasonable, Your Excellencies, in addressing the needs of the most vulnerable population members. The TWCCA Act, Your Excellency, provides no safety nets. It provides no just transition for the 2.5 million people in which it displaces. A further piece of locus classicus, Your Excellencies, is Sirac versus Nigeria, where the African Commission in 2001, the African Commission Law Report 16, found that regulatory measures must not disproportionately burden vulnerable population groups. And again, the court established that environmental rights and the right to life are indivisible. Now, the right to life, Your Excellencies, that we are highlighting here is the right for every single human person to human survival and the right to provide their own livelihood and sustenance, Your Excellencies, and the TWCCA takes this away. To conclude on this merit, the main submission or the main point that we're trying to put across to Your Excellencies is that climate obligations are not a blank check to override existing human rights, Your Excellencies. And the ICJ advisory opinion was not created in its principles to allow for the disregarding and the discrimination of other existing rights, but is asking for states to create a balance. As if one side of the pendulum falls, Your Excellencies, there is no balance that is created. Maneuvering on to merit 2, the main question before this honorable court is, considering that Azania had a pre-regulatory failure, should this honorable court consider this to be a lack of due diligence? And we would like to affirm that it should. The facts at page 3, section B, highlight that there was 35 and currently 35 to 45% of the disposable waste within Azania was disposed of without any regulations, Your Excellencies, the same regulations that our learned colleagues were talking about. This is at the hand of the state's indiscretions. The issue that we then take forward, Your Excellencies, is that the TWCCA Act is arbitrary in nature as it creates so many policies, Your Excellencies, that are trying to respond to previous negligence at the disadvantage of the 2.5 million Azanians. In the locus classicus Australia versus Japan, in this very court, in 2014 at page 226, presiding judge Peter Tomka highlighted that enforcement measures must be reasonably designed to balance the interest of all stakeholders involved. The TWCCA Act does not balance any of the stakeholders that it is supposed to govern, Your Excellencies. The analysis that we draw from this, or the main point that we're trying to arrive at, is that there is a lack of due diligence at the part of the state of Azania. And the rule of law that we rely on is the Basel Convention, Article 4.2b, which highlights very clearly, Your Excellencies, that all states are required to provide for the necessary disposal facilities for all hazardous waste, not the citizens of Azania, not the informal circular actors, Your Excellencies, the state. So the state of Azania, Your Excellencies, cannot run away from its due diligence obligations. Moreover, Article 10 goes again to say, Your Excellencies, that all state measures in fighting against climate mitigation must be done gradually. We are not here to argue, Your Excellencies, that the TWCCA Act should not protect against the environment, or that the state of Azania should not realize its intended aim and the fight for environmentalism that we all believe in. We are arguing against the way that they have implemented this, Your Excellencies, at the disparagement of rights owed to the state of Azania and their citizens. Moreover, the International Labour Organization recommendation number 204 for the transition from informal to formal economy regulations of 2015 highlights clearly that states must establish safety nets before initiating any sort of stringent measures that may cause friction within its citizenry. At paragraph 1A, Your Excellencies, it clearly highlights that the state must facilitate transitions for the informal economy to the formal economy in a manner where they have income security. That is not the prevalent case, as the state of Azania has initiated stringent measures that did not provide for any sort of transition for the 2.5 million people. We are not talking about 2,000 people, Your Excellencies. We are not talking about 250,000. 2.5 million people, and that is not a microscopic number that the state of Azania can continue to ignore. Moving on to my last merit, Your Excellencies, which has to do with whether or not the measures taken by the TWCCA Act should be considered trade violations at international law, or should they be considered to be justifiable. We take it to this honorable court that these stringent measures are not justifiable at international law. Particularly at page 3, section C of the facts, it is highlighted that the TWCCA Act mandates for passports, digital passports, I beg your pardon, and limits market access for non-certified economy actors, circular economy actors, Your Excellencies. Page 1 highlights that Azania is a developing state, and it is prevalent that the majority of the Azanians who are a part of the second-hand clothing sector will not be able to afford the stringent measures that have been put in place by Azania. So the issue that we take, or the central issue that we take with this particular point, Your Excellencies, is that the TWCCA Act is not proportional in its trade limitations, and they are and should be considered by this court to be protectionist. The rule of law that we rely on, firstly, is Article 27 of the UN Convention, I beg your pardon, of the Vienna Convention on the Law of Treaties, that states that when a state initiates any domestic laws, they do not supersede international laws. Moving on, we would like to rely on the General Agreement on Tariffs of Trade, particularly Article XX(b), which was highlighted graciously by my learned counsel. However, we would like the court to see the perspective of SECA when reading this particular article. Yes, it does permit for measures that protect the environment, Your Excellencies, to be put in place, but only if they are necessary and proportionate. That is not the current case that we have before this honorable court. Particularly, Your Excellencies, the TWCCA Act should be considered to be discriminatory, as it only highlights or discriminates against a certain social economic group, particularly the second-hand clothing economy actors, Your Excellencies. And Article 26 on the International Covenant on Civil and Political Rights bans this discrimination. Moreover, Your Excellencies, in the African Commission on Human and People's Rights versus the Republic of Kenya, application number 006 of 2012, Justice Sylvain Orr found that environmental conservation cannot destroy a population's socio-economic survival, and all measures to protect the environment must be balanced using the necessity principle and the proportionality principle. Your Excellencies, the necessity test that we would like to draw from was heard by the World Trade Organization in the Korea beef case with the citation WT/DS161/ABR of 2001. And it breaks down the necessity test into three main points. Firstly, it asks the court to look at the importance of the measure that is initiated, which we can argue, yes, environmentalism is a key and critical sector that must be addressed. However, Your Excellencies, when we now go into the second and third points, which are the contribution, how much does this measure actually contribute in this mitigation? We can argue, Your Excellencies, that the TWCCA Act has not actually shown any evidence of helping against the mitigation of climate change, but instead has created a further problem by disassociating and discriminating against 2.5 million people without any law backing it. Lastly, it looks at the restrictiveness of the measure, Your Excellencies, and as I've highlighted before, it restricts the ability of 2.5 million workers to be able to access a livelihood, which is protected under Article 6 of the International Convention on Economic, Social, and Cultural Rights, and furthermore, Article 11 of the Right to an Adequate Standard of Living. Your Excellencies, I would now like to cite another European court, the European Court on Human and People's Rights, in Sidibras versus Lithuania, application number 55480/00, where presiding judge Lucius Lucadas found that far-reaching bans that prevent an individual's right to work, Your Excellencies, and earn a living breach the European Convention on Human Rights, Article 14, and cannot considered to be a law at all. We would like you, Your Excellencies, as a closing statement, to borrow the reasoning of the former Judge President of this very court, Judge Weremansi, who in his dissenting opinion in Hungary versus Slovakia of 1997, page 7, established, Your Excellencies, that the right to protecting the environment and the right for a person to be allowed to economically develop and have access to jobs are not separate points. These socio-economic and environmental rights should be married and should be coexisting within the field of law. They should not be pit against each other, Your Excellencies, and there should not be a tit for tat considering whatever situation is brought before this court. Instead, Your Excellencies, as we've been asking the state of Azania to do, is not to choose one or the other, not to say that socio-economic rights should prevail over environmental rights. No, Your Excellencies, we are asking them to balance both interests to ensure that not only the environment is protected, but also the socio-economic rights of the citizens of Azania are protected, vice versa. Your Excellencies, the state of Azania has failed to proportionally establish a legal argument that clearly identifies why they have initiated such stringent bans. We would further like to pay attention to the ripple effect that is created once these 2.5 billion Azanians have lost their jobs. As was highlighted by Her Excellency Presiding Judge Amondi, there has been a violation of the rights owed to women, which are protected by the Convention eliminating discrimination against all women, as well as the rights owed to children, protected by the Convention on the Rights of the Children, particularly Article 27, Sub-Article 1 of the CRC, and Article 14, Sub-Article 2.1, that protect the adequate standard of living owed to all citizens. The ripple effect that we are seeing, Your Excellencies, and I'm sure you will see as well, is that if a person has no right to work and create a living for themselves, how are they supposed to sustain themselves? How do they access the right to shelter? How do they access the right to water? How are children then allowed an access to education? So the main issue that we raise is not necessarily the fact that there are stringent bans that have banned a certain sector, Your Excellencies, but the continuing ripple effect that these provisions in the TWCCA Act have created more harm than good, Your Excellencies. And to close off, I would like to cite the case of Olga Tillis versus Bombay Municipal Corporation of 1985, which again is brought before this court for persuasive reasons. The Chief Justice, Y.V. Chandrashad, highlighted that the right to life is indivisible from the right to work. You cannot remove one and protect the other without causing mass human destitution. And we pray that Your Excellencies find the same reasoning. Now, to not take up too much of the time that we have left, I would like to cede the floor to my co-counsel to continue our submissions. Most indebted, Your Excellencies.
Team UZ, you have 20 minutes.
Lead counsel for SECA. I will take this court through substantive issue 4 to 6, as previously mentioned by my lead counsel, and thereafter conclude with our prayer for relief. If the court is so pleased, I shall now proceed on to substantive issue number 4. We submit that the mandatory requirements under the TWCCEA constitute unlawful discrimination and disproportionate exclusion against informal economic actors. Under Article 2, Sub-Article 2 of the International Covenant on Economic, Social, and Cultural Rights, discrimination is strictly prohibited, including indirect discrimination, where a facially neutral law disproportionately impacts a specific vulnerable group. Now, the World Trade Organization appellate body, in its landmark 1998 ruling of the United States Shrimp Turtle Dispute number 58, under presiding member Florentino P. Feliciano, specifically at paragraph 159, upheld that the right to regulate is strictly bound by the standard of proportionality. This means that if a state imposes a regulation without offering transitional support, the law fails the mandatory requirement and test of proportionality and therefore amounts to unlawful indirect discrimination. Now, applying this legal standard to the present matter, if I may direct Your Excellencies to page 2 of the fact sheet, Azania's second-hand informal economy employs 2.5 million people, the vast majority of whom are comprised of women and youth who are inside the informal urban economy. Now, if we turn to page 3, I beg your pardon, paragraph C, the state of Azania has introduced the TWCCEA, which has brought in sweeping digital traceability and capital-intensive extended producer responsibility requirements for all second-hand apparel actors. This very same act has created a high demand for an under-resourced actor to meet the same exact compliance with a multi-billion-dollar actor. This extreme unfairness and inequality, Your Excellencies, is the exact definition of disproportionality as defined by Judge Tanaka in the Southwest Dissent cases of 2006. By enforcing high-cost mandates without offering transitional support, the state of Azania has abused its regulatory power. This has created an unlawful barrier to market participation, directly violating Article 6 of the African Charter, the right to work, Article 11 of the International Covenant on Economic, Social, Cultural Rights, the right to adequate standards of living, as well as the General Agreement on Tariffs and Trade, the chapeau under Article 20 of 1948, which strictly prohibits arbitrary discrimination. In that regard, Your Excellencies, Council for SECA submits that environmental sustainability cannot be built upon the economic destruction of the poor. The TWCCEA, in its unmitigated form, constitutes unlawful discrimination to the environmental end. Now, I will now move on to substantive issue number 5. We submit that while the exposure of children in coastal communities to apparel-related waste is a severe environmental concern, the legal and financial blame rests squarely on the global north states who export this waste, not the domestic circular actors who are merely managing this same waste. Now, the polluter pays principle as codified under Principle 16 of the Rio Declaration of 1992, which finds its customary foundation in the Trail Smelter Arbitration between the United States and Canada, published in Volume 3 of the United Nations Reports of International Arbitral Awards, specifically at page 1905, where this court upheld that under presiding neutral chairman John Franz Hosty, specifically at paragraph 1, page 1905. The sovereign state originating the harm is held directly and exclusively accountable for the transboundary harm. This means that international environmental law creates an unbroken causal chain dictating that the state originating the ecological hazard and no one else is directly accountable for the waste, is directly financially and legally accountable and responsible for the cost of remediation. Now, applying this to the present matter, if I may direct Your Excellency's attention to page 3 of the fact sheet. Environmental audits reveal that 35 to 45% of secondhand garments arrive Azania as pre-existing waste. This illustrates that secondhand garments already arrive Azania as contaminated, beyond repair, and damaged. The legal and factual polluter as per international law thereby becomes the wealthier nations within the global north. They have violated the no harm rule. They have initiated the transboundary risk. Under international environmental jurisprudence, the state of Azania's due diligence obligation was to aggressively confront the transboundary flow at its geopolitical origin, as our learned colleagues have earlier conceded that international law imposes a due diligence obligation on all states to aggressively confront a state to not cause harm within another environment. Now, the state of Azania has not done that. International law does not allow it to punish the domestic economic actors who are merely managing the downstream fallout of international waste dumping. Therefore, Your Excellencies, we submit that the remedy chosen by Azania is a legal error. International law demands that the burden of transboundary harm must be borne by the nations who generate and create the waste, not emerging economies who are merely trying to survive it. Now, I shall now move on to substantive issue number 6. We submit that circular social enterprises are legitimate governance actors in fulfilling climate obligations, in fulfilling state climate obligations. At the very outset, we would like to state that, as our learned colleagues have earlier mentioned, that state climate responsibility should not exclude everyone. Everyone should be involved in this. In the Gapsikavo Najimaris ruling, ICJ reports 1997, ICJ Judge Christopher Weirmantree explicitly argued in his separate opinion, specifically at page 111, section BA, that climate governance should be dynamic and flexible. Compliance is no longer a domain monopolized by the state alone. Now, under Article 12 and the preamble of the Paris Agreement, read in tandem with Article 6 and 7 of the Aarhus Convention and Article 7 of the Escazú Agreement, as well as Principle 10 of the Rio Declaration, states are legally bound to guarantee public participation to states are legally bound to guarantee access to information and public participation. In the case of Sarak versus Nigeria, communication number 155/96 of 2001, the African Commission under presiding chairman Commissioner Kamal Bara upheld specifically at paragraph 53 that compliance with human rights requires providing affected communities with meaningful opportunities to be part of decisions that affect their land. This means that environmental law creates the concept of state sovereignty is no longer an absolute shield that permits a state to monopolize state climate governance alone. Emerging international law obliges a state to recognize multi-level climate governance. Now, applying this to the present matter, if I may draw your Excellency's attention to page 9, first section, number 4 of the fact sheet. Circular social enterprises are engaged in reuse, repair, and resale. This illustrates that they are performing a critical public service in removing waste from the land. They are actually forming part of the climate solution. The United Nations Environmental Programme in 2023 actively championed that. Doubling the average use of garment via reuse, resale, and repair, which is second-hand sustainability, actively reduces greenhouse gas emissions by 44%. Your Excellencies, clearly circular social enterprises are the solution, not the problem. The Paris Agreement preamble legally scaffolds circular social enterprises to breach the execution gap where the state fails. As illustrated by the fact sheet, the Republic of Azania for three decades failed to address environmental harm. This therefore shows the importance of circular social enterprises in assisting and helping the state in executing the gap of removing waste from the land. In the landmark 2018 study on multi-level governance, writing on page 1 of this text, Dr. Vera Rodenhoff, the head of division of International Climate Cooperation, authoritatively argued that to achieve the climate goals of the Paris Agreement, we require dedicated efforts and cooperation. This extends the need to involve and include circular social enterprises who actually form the operational backbone of localized green transitions. Your Excellencies, in that regard, Council for SECA submits that circular social enterprises are legally competent environmental governance actors in international law. If the court is so pleased, I will now give in our prayer for relief. In light of the foregoing, SECA respectfully requests this court to adjudicate and render in its advisory opinion that 1. The state of Azania is required under international law to adopt proportionate environmental regulations that do not prejudice or exclude legitimate market actors. And 2, human, economic, and environmental rights are to be pursued in a complementary and integrated manner without excluding one or the other. We would like to leave this court with the words of the distinguished legal philosopher Brian S. Turner, who authoritatively argued in his 2006 landmark that human vulnerability is the very reason human rights law exists. As we stand at this crossroads of justice, only this court has the power to ensure and decide that whether climate action must come at the cost of 2.5 million people, or whether climate justice, as envisioned in the Paris Agreement, can truly be justice for all. Today, we ask this court to affirm a balanced vision where environmental regulations and economic rights move in parallel, ensuring that climate action must protect the environment without outlawing the very people who sustain it. If the court is so pleased, this concludes our submissions for SECA. Thank you, and may it please the court.
Thank you, Council, both Council for SECA. We'll go again through with the judges on the bench. Honorable Justice Bozi, Professor, any issues you'd want Council for us for SECA to address?
No, thanks, Judge.
Thank you. Senior Counsel, Honorable Judge Eric Theory.
Thank you, Presiding Judge. I just wanted to pose a question to the team from SECA with regards to their submission on the question of the polluter pay principle. If I understood your submissions, that it is the persons, or rather the regions in the North of Americas where the apparels are coming from, should actually bear the responsibility to compensate for the damage to the environment. If that then is the case, doesn't the law that imposes the obligation for digital traceability actually mitigate, or rather comply with the principle of polluter pay? Because my understanding is that it seeks to stop the importation of the corrupted apparel, as opposed to the obligation that is now arising on the part of Tanzania to deal with it. And I say this in view of the fact that during their submissions, the state of Tanzania submitted that at a certain point, due to the absence of scientific evidence, they viewed the apparels more of as a trade, as more than as a threat to the environment. So that I'm just looking at that balance, and I wanted to just find out what your response would be to that question. Thank you so much, and thank you for your very, very well made submissions.
Duly obliged, Your Excellencies. I will answer your question in a two-pronged section. Firstly, international environmental supreme jurisprudence speaks in one clear voice. Transboundary harm must be borne by the state that creates and originates the waste. Now, the polluter pays principle creates a direct conduct to the main polluter. The state of Tanzania has implemented the digital traceability to address local domestic circular actors who are involved in secondhand trade. They, however, haven't exercised their international power granted to them to confront states within the global north. International law imposes a strict state-to-state accountability, as similarly exercised in the Gapsikovo-Najimaras case, as well as the Trailsmitter arbitration, whereby international law imposes an obligation on a state to directly confront another state when it is causing harm within its territory. However, the state of Tanzania has not exercised this right. It has instead misdirected this power to circular domestic actors who are merely managing this. This therefore creates a legal error of where their power is actually supposed to go to and where the law is actually supposed to be addressed to. Now, international law does not create an intermediary obligation. It obliges the originating creator to bear the responsibility and cost of remediation when transboundary pollution occurs, especially as that is what has happened in the Republic of Tanzania. I hope I've answered your question, Your Excellency.
Yes, you have, and thank you so much. No further question from my end, Presiding Judge.
Thank you, Judge. Honorable Judge Antoinette Ogange.
Thank you, Presiding Judge. Allow me to proceed with my video off for better audio. I've heard both counsel for SECA submit on the case of SERAC versus Nigeria. And essentially, this is a decision by the African Commission, and thus a recommendation. Are you aware whether that decision has been implemented? And what exactly would be the legal status of that case in this court? Is it a binding decision, a recommendation, or a persuasive regional jurisprudence in your view?
Most indebted, Your Excellency. To answer your question, the reason why we have provided that case is number one, considering the fact that the case clearly highlights exactly what we've been trying to articulate before this honorable court, that the right to protect the environment should be considered to be indivisible. And to answer Her Excellency's question, we do consider this to have persuasive value, which again we would like to state we are allowed to do under the ICJ statute, specifically Article 38, where the court allows for any members who have come with their cases before this honorable court to express other cases from different jurisdictions as well as other legislatory provisions. If Her Excellency is answered.
Just one bit of that question. Are you aware whether that decision has been implemented? Because it should inform what you feel it is to this court.
Most indebted, Her Excellency. I would like to state that I'm not sure of the implementation as it currently stands, but we would still like to maintain that we firmly and strongly rely on the jurisprudence that was dictated, considering that it clearly highlights exactly the question that was brought before Counsel for SECA. And I feel as if we have further articulated that the main point that we are trying to draw from it is, number one, that human rights and the right to the environment are indivisible, and we should not consider these to be separated in our interpretation of the ICJ advisory opinion of 2025 that is currently in contention before this honorable court. If Your Excellency is pleased.
Thank you for your response. Thank you, Presiding Judge.
Thank you, Judge. Honorable Justice Mukule.
Judge Mukule, you are muted.
Yes, there I am. Can you hear me? Yeah, I would
Yes,
like
Judge,
to
yes.
reiterate the question. Yes, I would like to reiterate the question pursued by the Judge, Senior Counsel Kacheuri, on the question of liability of the global north. Counsel Masango, is it your view that the global north should be responsible in this case for the 30 or 45% contaminated apparel that's imported into the global south?
Duly obliged, Your Excellencies. Yes, we do believe that the global north should be held accountable for the waste they continuously dump in emerging economies in Africa. This has created waste colonialism, which should be banned, and in our view, common but differentiated responsibilities. In our view, the global north should ensure that the textile waste that they produce yearly should not affect the countries in Africa and should be stopped at the geopolitical origin. I hope I've answered Your Excellency's question.
Thank you. Thank you, Counsel. And thank you, the team, for very clear submissions. Thanks, Presiding Judge.
Thank you, Judge. For me, still following up on that issue of digital traceability and the responsibility being shared with the global north, it creates the impression of what has been seen as Africa's attitude of a sob story, always acting helpless and always blaming the North. These garments, one, are imported by the fast fashion industry, which I presume are private entities. And number two, when they are being imported, are they being imported on a charitable basis, or is this some kind of contractual agreement so that nobody is forcing the garment industry to bring them to Africa? Maybe that is one. If you could answer that, then maybe I'll follow up with something else. And maybe in answering that, you can look at your paragraph 18 of your submissions, which are on page, I think they're on page 13.
Most indebted presiding judge, to answer your question, I do agree that Africa has a tendency to look as if we do not have the facilities or do not have the necessary knowledge in order to fight climate change, which I do believe to a certain extent is true and false at the same time. As Africa, the majority of the countries in Africa are developing nations. However, in us being developing nations, it does not mean that we are restricted or incapable of protecting the environment, because protecting the environment does not necessarily require major backblows, considering the fact that Africa in herself negligibly contributes to climate change in comparison with the global north. The argument that we were trying to raise, Your Excellencies, and providing evidence from the UN report that was published in 2025 in regards to secondhand clothing, that the global north deposits 46% of its secondhand waste that usually, Your Excellencies, has a rate of being from 75 to 85% unusable. Your Excellencies, the main issue that we are trying to raise or that we are trying to highlight is, yes, Africa has to do better in terms of the way that it mitigates against climate change, Your Excellencies, specifically with the imports that we accept. However, in creating these measures, Your Excellencies, they should not exacerbate any sort of discrimination, as again was highlighted, or to re-emphasize, was highlighted by the advisory opinion. In all measures that are initiated in protecting the environment, there must be a proportional balance that is struck, and that I do not believe creates an image of Africa being weak or Africa not wanting to fully realize or fully participate in the global fight against climate change. We are just looking at the global capacity that we have as developing nations, which I think Her Excellency can agree we cannot ignore. Africa, unfortunately, but not permanently, is not at the level of first world countries to fight against climate change. However, we are in a position to start and continue to start every single day. If Your Excellency is pleased, I would like to please refer to my laptop, as we only have a digital copy of our memorial, to refer to paragraph 18.
Okay.
Most obliged, Your Excellency.
It's on page 13.
Thank you, Presiding Judge. I found it. Paragraph 18 specifically highlights paragraph 308 of the advisory opinion, which does confirm that there must be a cooperation of societal actors, including informal economy participants. And I think my co-counsel, Your Excellency, had highlighted that we are looking for the informal actors to be considered as partners and not conduits of this climate degradation within Azania, and they should not be considered as the main conduits, which is exactly what my co-counsel answered previously, that in terms of the polluter pays principle, the main issue that is raised is that the main conduit, and using the statistic that I gave you, that 46% of the imports from the global north end up in Africa. That is nearly at 50%. So instead of considering the circular informal actors to be conduits or to be considered as a nuisance, the state of Azania should partner with them, Your Excellencies, in the fight against climate change. And again, I would like to give an example of the OR Foundation within Kenya, which has partnered with even domestic secondhand clothing communities in Ghana, where they have implemented lessons, Your Excellencies. It starts in a very small scale, letting the secondhand informal actors know what their contribution is to protecting the environment and how they can reuse, resell, and mitigate against climate degradation as my co-counsel has previously highlighted. If Your Excellency is so pleased, I hope I've answered your question.
Yes, indeed you have. Thank you very much, Counsel. I think that brings to the end issues that the bench wished to be addressed. So we'll get back to the registrar.
Thank you. Thank you, Presiding Judge, for that session. Now we go into the session for rebuttals. Each team will have 8 minutes. We'll start with Where with your rebuttals.
Thank you, Presiding Judge. For the 8 minutes graciously allocated to me by this Honorable Court, I will invite this Honorable Court to see beyond the smoke screen that the coalition is trying to put across, Your Excellencies. This smoke screen that is trying to confuse the issues before us, that reminds me of a quote made by Humpty Dumpty in Alice of Wonderland, where he said, "When I use a word, it means just what I choose it to mean, neither more nor less." When Alice questions whether words can have such arbitrary meanings, Humpty replies that it is a matter of who is in control, the speaker or the language itself, Your Excellencies. Your Excellencies, the Coalition of Ethical Circular Apparel, as they began their submission, reiterated how the regulatory forum that the state of Tanzania is trying to put is a regulatory roof, Your Excellencies. But we submit before this Honorable Court that that regulatory focus is a regulatory flaw, a flaw that will be the basis upon which Tanzania can ensure that the industrialization process of the trade is environmentally sound and incorporates the current contemporary issues of climate change that we are facing today, Your Excellencies. The state has made reference to how the coalition has made reference to how Tanzania is a developing state, Your Excellencies. But however, Your Excellencies, they have adopted the majestic equality that Judge Yusuf noted, whereby the law in its majestic equality forbids the rich as well as the poor to sleep under the bridges, to beg in the streets, and to steal bread, Your Excellencies. By adopting such a general majestic equality, Your Excellencies, the Coalition of Ethical Circular Apparel is disregarding that the due diligence obligation is one that has to encompass the scientific realities, Your Excellencies, and the principle of the common but differentiated responsibilities, Your Excellencies. And thirdly, in their submissions, Your Excellencies, they brought about the issue of balancing rights in regards to the social and environmental rights, Your Excellencies. We have submitted as the state of Tanzania that we propose the implementation of polycentric systems that are a just transition model to incorporate the informal circular economy workers, Your Excellencies. At the same time, we have digital tracking passports and grading requirements, as well as extended producer responsibility requirements, Your Excellencies, that ensure that this trade is environmentally sound, Your Excellencies. Meanwhile, the Coalition of Ethical Circular Apparel has not provided a means of ensuring the environmental rights are respected, Your Excellency, other than the waste management alternative measure, Your Excellency. And allow me to mention a report that was put by the World Bank, whereby they provided that enhancing the waste management, municipal solid waste management, would require between 1.1 and 5.5 billion US dollars of initial capital, depending on the technology, and an annual 0.9 to 1.4 billion US dollars of annual recurring costs to construct and implement a comprehensive waste management system to serve as an alternative measure, Your Excellencies. And therefore, as Article 20 of the GATT agreement provides, this is no less trade restrictive alternative measure, Your Excellencies, because waste management is a downstream solution to an upstream source, Your Excellencies, which is the transboundary origin of the waste, making it inherently insufficient to meet the International Court of Justice mandate. For a developing state like Tanzania, expanding municipal infrastructure to capture tons of textile waste would impose an unjust burden, Your Excellencies. And I beseech this honorable court to ponder on this question. Is the continued exposure of women and children justified at the expense of reducing trade restrictions? On the second last argument that was put across by, my apologies, actually the last argument that was put across by the Coalition of Ethical Circular Apparel was in relation to the polluter pays principle, which was also brought up by Your Excellency Justice Eric Theory, whereby they beseech this court to find that the state is accountable to the cost of remediation. Your Excellency, we have
1 minute.
Thank you, much obliged. We have implemented exactly that by providing for point of quality inspections at the point of importation, which will be borne by importers and exporters, and not at the point of consignment where we have local circular actors, Your Excellencies. Because if we put this point of quality inspections at the point of importation, it will not target all local circular actors, Your Excellencies, but only those who let such contaminated apparels into the state, Your Excellencies. And allow me to quote the words of Mama Ruth in the Trashon report of the Cleanup Kenya, where she noted that if you buy the bale, you die with your problem. And that is one measure that we are trying to reduce, Your Excellency, whereby these circular actors are not affected. And with that, I cede the floor back to the bench. Thank you, Your Excellencies.
Thank you. I think unless there's any member of the bench that wishes to address anything, again in the same order, Professor Bozi.
No, thank you, Judge.
Thank you, Honorable Senior Counsel Judge Eric Theory.
Presiding Judge, I have no question.
Thank you, Honorable Judge Antoinette Ogange.
And Presiding Judge, thank you.
And Honorable Judge Matthew Emokule.
None, Presiding Judge.
None from me either. So, Honorable Registrar, you can ask the other party.
Thank you, Presiding Judge. Team UZ, we shall have your rebuttals. You have 8 minutes. You can have the floor.
Most indebted Registrar, I would like to apologize, but I'm the only one that will be taking rebuttals. Unfortunately, Kudakwashi is not feeling very well. She's had a medical emergency. So I would please ask the court to indulge us, as I'm the only one taking rebuttals. Your Excellencies, I would like to begin by addressing the lead counsel's submissions. In the very beginning of his opening statement, he stated that the state of Azania would not look away, per verbatim, from the pollution currently being caused in Azania. However, the facts at page 1 clearly highlight and demonstrate that for the last 30 years, they have been doing exactly that. Your Excellencies, the same due diligence standards that the state of Azania has continuously been arguing, Your Excellencies, and stating that is the reason why the TWCCA Act may seem as stringent or as rigid as it is, does not stand, considering the fact that for 30 years they have ignored previous policies and legislations, treaties, conventions that have implored them to protect environmental rights. I would like to highlight the Article 3, Sub-Article 3 of the United Nations Convention on the Framework for Climate Change, where it particularly states that every single state is mandated to cause for prevention and precautionary principles that protect against the environment. The state of Azania cannot balance these two arguments. It cannot have its cake and eat it at the same time. It is either that it had ignored previous human rights obligations to protect the environment, or it has not and is continuing to not do so, but instead is initiating policies that do not align with the global intention of the advisory opinion as well as international law, but instead is causing an infringement of other human rights for 2.5 million Azanians, particularly socio-economic rights, such as the right to work and the right to an adequate standard of living protected under Article 6 and Article 11. Moving forward, Your Excellencies, I would like to re-highlight the Basel Convention that clearly states that under Article 4.2b, it is the state that has the duty to mitigate or create facilities for this climate action to take place. It is not the citizens that must have Robin Hood's tendencies to protect the environment, although we do encourage, Your Excellencies, for every single person to be on their own just in their protection against the environment. It is the policies of the state that should implement this and should guide their citizens. Policies that should not be stringent, should not be arbitrary, and should not be rigid, Your Excellencies, as our learned counsels for Azania have been arguing today. Moreover, I would like to re-highlight paragraph 285 of the advisory opinion, which highlights, thank you, that highlights the common but differentiated responsibilities that we have been arguing, that the state of Azania, in collaboration with the Global North, have been the true conduit of climate degradation within Azania. We are not trying to hide and say that the second-hand clothing economy has not contributed negligibly, Your Excellencies. However, there is a system and a pattern that is followed, and it starts with the state before it starts with the citizens. To move on to my contentions with my learned friend, the second counsel for Azania, I would like to highlight the point that he made that sovereignty reigns supreme and domestic laws reign supreme over any other international legislations. This is incorrect. The Vienna Declaration on the Law of Treaties, particularly at Article 27, clearly states that states may not hide behind domestic laws when it comes to the protection of international human rights, Your Excellencies. And I pray that this court finds the same reasoning. And furthermore, I would like to argue about the mainstream technological innovations that have been initiated. We truly believe that these have worsened the economic divide and inequality, considering that Africa is a developing nation. I will not sit and argue and lie to the court that Africa does not have technology, but not to the certain thresholds and grade that has been initiated by the TWCCA Act. Azania has built a regulatory roof before it has built the foundation of structural, social infrastructure and inclusion. Your Excellencies, again, I would like to re-highlight that we are not arguing against environmental protection, but instead we are arguing for the just and balancing of socio-economic rights and environmental protection. If the court is so pleased, I will now conclude. I have now concluded.
Thank you. Thank you, Counsel. I think, Registrar, you can guide the next session, which would be the closing for prayers.
Thank you, Judge. Thank you, counsels, for the submissions. We now go into the final session, formal closure of the oral hearing. And as it has been indicated in the instructions and the rules, the judgment has been reserved. It will not be delivered now, but will be delivered within 14 days, wherein the Honorable Lady Justice Elena Mondi will give us, and we shall again for the judgment. But for now, I give it back to presiding judge for just give your comments of how the session has been, and then close the session by reserving the matter for judgment, and then we shall go to the next segment.
Thank you very much.
Welcome, presiding judge.
Thank you very much, Honorable Registrar. Let me, on behalf of the bench, express our sincere gratitude to all the counsel in this matter. You have conducted yourselves in a very professional manner. You have done very thorough research, and you have exhibited courtesy, even when we put you under what would appear as unreasonable pressure. And for that, we want to thank you. And I want to urge you to remain focused. You give me the impression of being very good researchers, and how I truly hope that this will not be the end of our interactions, at least in the other cape that I wear as president of the International Association of Women Judges, one of our focus area being climate change. I am truly hoping that we can maintain the contact and perhaps get you to even sit on a forum where you'd be able to share what is really very rich information that you all have. So may I, on behalf of my colleagues, thank you for that professionalism that you have all exhibited as counsel for the respective parties. Our decision will be made within 14 days. 14 days from today would ordinarily fall, I think, on it would end up being a Saturday, if I'm not wrong. And so the next working day, Honorable Registrar, would be, let me just be clear, I think it would be 5th of September. Let me just look at my calendar to be precise. So yes.
7th of September, presiding judge.
7th of September, right, 7th of September. So that is the date that we'll be able to make the decision. Because otherwise the 14 days will fall within the weekend. Thank you. And so with that, then it is to just wish each one of you in your endeavors all the best, and certainly hope we may be able to interact more. Thank you, and back to you, Registrar.
Thank you, presiding judge. Thank you for the bench for your commitment since this year with the preliminaries virtual rounds up to now. It's not easy to dedicate time for this, having in mind you have already packed schedules, but we thank you for the mentorship and the capacity building and the support that you have given to the Green Law Global Institute. To the finalists, as you've indicated, the judgment shall be read on the 7th of September. We shall communicate all those, and the champion shall be, so each of the 5 judges will write not more than 3 pages of their well-reasoned judgment with reasons for deciding. Then the champion shall be determined by majority decision of the grand final bench. And as we have indicated, as has been said, it's not about winning or losing, rather it's about capacity building in using the law as a tool to fight climate change. With that, I'd also like to indicate that these finals were supposed to be fully virtual, fully physical, with Team UZ and Team Quer being in Addis. However, we got visa delays from Team UZ, which visas came later. But nonetheless, a delegation traveled to Addis. The GLGI Secretariat, including myself, traveled to Addis. Greenpeace Africa came from South Africa all the way to Addis. So Addis Ababa acts as an institutional and partnership hub, where we spoke about capacity building together with our 3 institutions, Greenpeace, Green Law Global Institute, and Addis Ababa University Law School. And therefore, this finals has taken a hybrid matter. The finals has been postponed, I think, twice because of the visa issues, but I thank everybody for understanding. And Team UZ, we are still working to see how your visas will be used because they are still valid. So we'll discuss with a couple of partners and see how to help you before that goes. So allow me to take us to the final penultimate program, to the closing session of these finals. And I will invite retired Justice Matthew Emukule, Green Law Global Institute founding presiding judge, to issue his closing reflections and appreciation. Welcome, Justice Emukule.
Thank you. Can you hear me?
Perfectly well.
Thank you. Good evening, distinguished guests, colleagues, members of the bench, faculty representatives, coaches, students, partners, ladies and gentlemen. It's a great pleasure and privilege for me to join you at the culmination of the 2026 GLGI International Climate Justice Moot competition. When we began this journey, we knew that we were not simply organizing another moot court competition. We were attempting to create a platform through which young lawyers would engage seriously with some of the most consequential legal questions facing our continent: climate change, environmental degradation, sustainable development, environmental governance, and the responsibility of law towards present and future generations. Looking back at the journey we have taken, I believe that that objective has been substantially achieved. We have witnessed students engage with the complex questions of environmental law. We have seen them research deeply, construct arguments, respond to difficult questions from the bench, and importantly, learn from one another. The competition of this nature is valuable not merely because one team eventually emerges as the champion. Its real value lies in the lawyers it helps to form. Every participant who leaves this competition with a deep understanding of environmental law, stronger advocacy skills, and a greater appreciation of the relationship between law and environmental justice represents part of this success. And that ultimately is what a moot court should accomplish. At this point, I wish to express my sincere appreciation to the institutions and individuals who have made this competition possible. First, we extend our profound gratitude to Addis Ababa University Law School for its partnership, hospitality, and willingness to open its academic space, this continental initiative. The participation of Addis Ababa University has given this year's competition an important institutional and academic dimension, and we are deeply grateful to Professor Muradu and his colleagues for their continued support. I also wish to recognize my fellow members of GLGI bench for their time, intellectual commitment, and professionalism they have invested throughout the competition. I thank the participants participating institutions, particularly Catholic University of Eastern Africa and the University of Zimbabwe, together with their faculty representatives and coaches, for preparing and supporting their students through this demanding process. To the participants themselves, I say, well done. You have demonstrated courage, preparation, and intellectual curiosity. I also wish to recognize Greenpeace Africa, Agnes, and the other partners, observers, and institutions that have joined us and demonstrated confidence in the importance of environmental legal education. And finally, I commend Brian, our president and CEO at the Green Law Global Institute and our International Academic Advisory Board for conceiving and sustaining this initiative. The commitment required to establish a continental platform of this nature should not be underestimated. I'd like to make some comments on the future environmental legal education in Africa. Allow me, ladies and gentlemen, to turn briefly to what I consider the most important question arising from this competition. What kind of environmental lawyers does Africa need for the future? The answer, in my view, is that Africa needs lawyers who understand that environmental law cannot be practiced in isolation. Environmental problems confronting our continent do not respect disciplinary boundaries. Climate change intersects with land. It intersects with agriculture, intersects with water, it intersects with energy, it intersects with human rights, it intersects with the indigenous and community rights. It intersects with biodiversity, it intersects with development, and increasingly, it intersects with the questions of intergenerational justice. The lawyers of the future must therefore be capable of speaking across these disciplines. A young environmental lawyer cannot simply know environmental statutes. They must understand the communities affected by environmental decisions. They must be able to engage with scientific evidence. They must understand public policy. They must appreciate economics and development realities. They must understand international environmental agreements and have those commitments to translate into domestic obligations. And they must understand the constitutional foundations upon which environmental protection rests. This is why initiatives such as this Moot are very important. They provide young lawyers with an opportunity to encounter environmental law not as an abstract academic subject, but as a living system of rules and principles that affects real people and real ecosystems. But I believe we must go further. African universities must become much more deeply involved in environmental negotiations, research, policy processes, and implementation discussions taking place at the continental and international levels. Our universities should not merely teach environmental law after international agreements have been negotiated. They should help shape these ideas, research, and legal frameworks that inform those negotiations. We need stronger collaboration between universities, courts, practicing lawyers, governments, civil society, scientists, and international institutions. We need environmental legal education that is practical, interdisciplinary, and connected to the realities of African communities. And we must ensure that young lawyers are not merely trained to interpret existing law. They must also be equipped to imagine the law that Africa will need tomorrow. This is my message to the participants. To the young lawyers participating in this competition, I offer one final thought. Do not measure your success today only by whether you win. The law is a long profession. There will be cases you will win. There will be cases you will lose. There will be moments when the law appears clear and moments when the law represents difficult uncertainties. What will distinguish you ultimately will not simply be how eloquently you argued in a moot court. It will be the integrity with which you practice. It will be your willingness to prepare. It will be your courage to ask difficult questions. It will be your capacity to listen. And it will be your commitment to justice, even when the pursuit of justice is difficult. Climate change is going to create some of the most important legal questions of your generation. You'll be asked to advise governments. You'll present communities. You'll appear before courts. You'll work with the scientists, policymakers, and civil society. You'll confront questions for which there may be no easy precedent. You must therefore become lawyers who are not afraid of new legal frontiers. Be curious, be rigorous, be principled. And remember always that behind every environmental dispute, there are human beings, communities, and ecosystems whose lives may be profoundly affected by the outcome. In conclusion, as the year 2026 GLGI International Climate Justice Moot Court competition comes to its culmination, I hope we can regard it not as the end of a competition, but as the beginning of a much larger journey. A journey towards a stronger environmental legal education, a journey towards greater cooperation between African universities and environmental institutions, a journey towards a generation of lawyers capable of advancing environmental rule of law across our continent, and ultimately, a journey towards a legal profession that understands that climate justice is not simply an environmental question. It is a question of law, rights, dignity, development, and justice between generations. To all the participants, coaches, faculty representatives, judges, partners, observers, and organizers, thank you for making this journey possible. And to the young lawyers, you will carry this work forward. I leave you with this. The future of environmental justice in Africa will not be written only in legislation or judgments. It will be written by the lawyers, the judges, the scholars, and leaders that choose to nurture today. May you be among those who write that future with courage, integrity, and purpose. Thank you very much, presiding judge, my fellow judges, and participants. Have a very good evening. Thank you.
Thank you very much, Justice Emukule, GLGI founding presiding judge and resident judge. Thank you for those insights. I'm sure the participants have taken them into consideration. Before I invite the executive dean of AAU to close the session for us, kindly please allow me to recognize and invite a few crucial people in this journey who have made it possible, and possibly give them not more than 2 minutes to just say something. We'll start with my colleague at Semiride, Halima Dube. She's also my colleague at the International University Network. Halima, you can tell us what Semiride is and perhaps greet us, and then we proceed. Welcome, Halima.
Thank you so much, Brian. Thank you to the team that have presented, as well as all team members that have made this successful. Semiride stands for Center for Minority Rights Development. And for us, we have been leading in relation to litigation for the minorities and indigenous people within the climate justice space. And this has been an opportunity for me to learn. And one of my colleagues, Mr. Tinodiwa Taguma from Zimbabwe, and we will be able to relay information regarding what we've learned from this and see avenues of collaboration so that we can take this particular initiative to the next level. So thank you so much, and I'm looking forward to advancing this very critical agenda. Thank you. Back to you, Brian.
Thank you so much, Halima. It was short notice, but you promised you'll be here. It shows your commitment, and we truly appreciate it. I'll come to Madam Freda Kabatsi. We've been with this journey with you since the first Moot to now. Kindly, please. Welcome.
Thank you, Brian. Good evening, everybody. Well done, University of Zimbabwe. Good job, ladies. Well done to my team from CHOER. They have worked so hard. Good job. I did mention to Brian, I think in an email, that we do have an elective course, International Environmental Law. And, you know, because depending on the customers, it wasn't one of the popular ones, but we have now decided, because of this Moot, that we shall always offer it, you know, because of the importance. And I think Nick and Timothy know that in their cohort, many of them requested for this course. And Brian has promised to come and teach a few things for free. Thank you, judges. Thank you, everybody on the call. Have a good evening.
Thank you, Madam Freda. And actually, that was one of the discussions we had with Greenpeace and AAU Law School this morning, so that environmental law should no longer be left with an elective, but it becomes a core course in our universities. Thank you so much for that. I'll invite, we have a media correspondent from the WAVE in UK. So this thing might be reported in the United Kingdom. I'll invite Joseph Miner. Kindly, please. Thank you. Joseph, are you there? Can see him on call. As we wait for Joseph, Madam Tigis Tendashow, our coordinator and our focal person in Addis on the ground. You've been very crucial in everything. Kindly, please.
Thank you. Thank you so much. I really apologize for this background noise as I'm on the road. But this has been really great, a great experience, a great journey, an amazing journey from the start to finish. I work as a consultant in climate action policy advocacy, so it's really amazing to see the passion by the participants, the dedication, the efforts that has been really put into this effort. And I would like really to take this chance to congratulate all the finalists, as well as I want to extend my sincere thanks and appreciation to the presiding judges who have been there for us all throughout, sharing your wisdom, sharing your knowledge, giving it your all. And this has been honestly like as a great lesson to all of us who are following in your footsteps. So I really want to extend my thanks and appreciation. At the same time, I also want to iterate my personal as well as all our dedication to make sure that we really make sure we take this as forward as possible, as needed and as wanted and as planned. And I am sure this is going to grow. And really, this initiative is going to be an example also globally and motivate many more we look forward to the coming years. And again, I just want to say thank you so much to everyone.
Thank you, Tigist. Thank you so much. It's been a pleasure working with you, and we shall indeed continue. Now, allow me lastly, before I invite the Executive Dean, to invite Professor Thomas Bayer, someone who's been very important in this journey and in my evolution as an advocate. He is the director of the African Institute at HNU University in Germany, and also part of the GLGI International Academic Advisory Board. Welcome, Professor.
Thank you, Brian. Good evening, all the members from Catholic University of Eastern Africa, from the University of Zimbabwe, the bench members, and good evening also to all the participants and observers from external organizations. It's been a pleasure to listen in only on the last few minutes, but I've been following the process of this Green Law Global Institute Moot Court process over the last couple of months already with Brian, and I'm very proud that you have achieved in your Moot Court negotiations such an highly and well-researched dispute, which I've just listened, as I said, the last couple of minutes. I like to say also thank you to Brian for this excellent organization. And I think it was the first Moot Court in this direction, but I have the feeling that this topic is so important globally and internationally, so important that there will be more of this coming. And I like the words of Justice Mukule just before saying this is really a truly important direction where not only law is going, where not only you as young advocates are going, but it's also an interdisciplinary initiative. Yeah, you mentioned, Judge Mukule mentioned clearly the connections to other subjects, and I'm joining in here not coming from a law background, I'm coming from a business background. I've been working with Brian and his team also on similar issues, circular economy in the apparel fashion, during the last semester with some of my students here. And we were working on the business side of these things, on circular business models. How could this be implemented? And therefore, I would also encourage all of you participants in further use this as an education, use this as a means for personal growth if you go further in this direction, because I think it's one of the most important legal challenges and global challenges, environmental challenges we have ahead of us. So thank you. Thanks to all of you. And I wish you good luck for the rest of the journey, and hand over to Brian. Thank you.
Thank you so much, Professor, for the support over the years. And thank you so much for everything that you do for GLGI. Now allow me kindly and humbly to invite our Executive Dean at Addis Ababa University Law School, Professor Muradu Abdo, to issue the closing remarks, and then we can wind up the session. Welcome, Professor.
Thank you. Thank you, Dr. Brian Awanda, for this kind introduction and the opportunity. Honorable justices, participants, contestants, thank you for being part of this milestone occasion. Good evening, everyone. I guess for most of us, this is an evening session. I'm delighted to take part in this process. Today's event is a result of an emerging partnership between Addis Ababa Law School and Green Law Global Institute, which is based in our good neighbor, Kenya. Brother Brian of GLGI is proposing to us to turn our laws greener. Our laws are to some extent green, so are our institutions and some of our activities. An example for this is this year on August the 3rd, Ethiopia planted 805.3 million tree seedlings in a single day. This happened during a nationwide mobilization of over 26 million citizens. A similar move was made in several years in succession. In this successive nationwide tree planting endeavors, resources for preparation of seedlings were generated from, and mobilization for the planting have been made by the national government. In Ethiopia, environment and climate change laws and institutions are in place. Major cities in Ethiopia, including Addis Ababa, are becoming greener. Ethiopia's green initiative have been lauded continentally and globally. The selection of Addis Ababa to host COP32, the United Nations Climate Summit, next year is a global recognition of these investments. These initiatives are not enough, far from it. That's why we have agreed with the proposal of GLGI to become further greener. Our law schools need to go greener in their curricula, in their training. The judiciary and the lawgiver need to be sensitized more. Our youth should be educated more about climate change. We must make these interventions because climate change is one of the existential threats to humanity in the 21st century. The effects of climate change are shattering livelihoods, destroying lives, and it is making areas inhabitable. These harmful effects are more so in our continent that contributes to the least to the cause of climate change. There lies the injustice of suffering from the effects of climate change to humanity living in the continent of Africa. Injustice needs to be remedied and fought back. To repel injustice, we need analytical, logical, and critical legal minds. We also need climate change leadership. More importantly, we need people with justice disposition. We need to produce people who ask the questions whether we really deserve this. Which part of the globe should do what, to what extent, and why? These are critical questions that need to be asked by our young lawyers. Young people in Africa, as elsewhere, cannot be born with analytic, critical inquiry skills, nor can orientation towards climate change justice be an innate one. So is climate change leadership. These are qualities which must be acquired and results of intentional legal education, training, and competition. Today's final Moot competition on climate justice is significant to help young African lawyers acquire these basic lawyerly qualities. It should be commended for that. We are happy in co-hosting today's hybrid grand final event. I'm sure the partnership between AAU Law School and GLGI will endure. Our law school is the oldest modern legal education trainer in Ethiopia. The school is located at the heart of the national capital. It is one of the few continental and global diplomatic hubs. Our school runs more than 7 academic programs with several environmental and climate change related course offerings. We have some colleagues with environmental and climate change orientations by training, research, and public action. The school has ongoing partnership with key government institutions, civil society organizations, and universities worldwide. We have 1,500 current students, the brightest the nation can offer. We command more than 6,000 alumni. We run free legal services. We have at least 5 annual publications. We can mobilize some of these resources to the cause of climate justice, which knocks on the doors of each and every African, affecting us in the most consequential manner. But we can and should manage and reverse this adverse impact. We cannot be a sitting duck. The school remains thankful to all those who made it happen. Thank you very much. Yeah. Yeah, back to you, Dr. Brand.
Thank you so much, Professor. Indeed, I can attest your law school is beautiful. We had a small tour there. Thank you very much. It was a nice place to visit today. And before we leave, we shall do more because it's a big place. I believe we haven't visited everything. So as we conclude, there is someone that is a silent figure in all this, someone who holds to acknowledge you, say hi to something. You've been our IT person from the word go. You've been patient with us, everything. You're always the first one to log in and the last one to log out. Kindly please just greet us and then we conclude.
Thank you so much for the opportunity. My name is Simon Wekesa, the ICT IT person, and I'm really grateful for interacting with all of you wonderful people. And thank you once again. Back to you, Dr. Brian. Unmute, you are muted.
Oh, sorry, I was saying you can give us a final virtual photo and then we conclude the session.
All right, we can all open our cameras kindly. All right, I'll be taking the photo. In 1, 2, 3. Hold on for the last one. All right, thank you. That's all.
Thank you very much for Madam Tigist and Freda for those smiles. You have enlightened the photo. Thank you. With that, from my end, I think today is when I will have a good night's sleep because it has been hectic. It has been hectic since April, but the support of the bench and everybody, Simon, everybody, I truly appreciate it. And I believe after this session, I'm just going to sleep directly. And thank you all for everything. Bless you. You are free to leave the platform. Thank you.
Thank you, Brian.